Good morning, everyone. You'll notice that Judge Zayas is not here today. She couldn't make it, otherwise she would be presiding, but she will be watching the arguments on YouTube and participating in our conference afterwards. So we have three cases up for argument today. The first case is Riverside Drive Enterprises versus Geo Technology, case number C-220099. And for Riverside Drive Enterprises, we have Mr. Fagel. Good morning. We have Geo Technology, Inc.
Sean Blatt.
Good morning, Mr. Blatt. And then for Evans Landscaping.
Good morning, Your Honor. Brian O'Connor.
Good morning. And then for SP Contracting. Okay, good morning. And I was informed that Geo Technology will be taking 7 minutes. Evans Landscaping will be arguing for 3 minutes.
Correct.
Okay, and then SP Contracting will be arguing for 5 minutes. Okay, and then I'll just go through the rest of the docket real quick because we had a slight change due to a little bit of confusion here, but the Liggett versus Liggett case will be second, and that is who's going to be arguing for the appellant?
Zachary Smith on that.
Okay, so we'll have you second, and then for the appellee is not here yet, I don't think.
Ms. Keller is in trance. She thought it was going to be by Zoom, so I guess she's.
Okay, great. And then the third case that's going to be argued is it Brazali versus Infrastructure and Development Engineering?
Brazil, Your Honor, Jason Conte for the appellant,
Brazil, okay. Good morning.
Good morning.
And for appellee?
Scott Jones on behalf of IDE.
Okay, perfect. Thank you. So you all will be arguing third. All right, so we'll start with Riverside Drive, and Mr. Fagel, would you like to reserve any time for rebuttal?
I'll reserve 4 minutes.
4 minutes, okay. And I'll be using the lights on the podium. When you have a minute left, the yellow will light up and then red's for start. Okay.
May it please the court, counsel. So this obviously is our appeal. The facts of this case, and I'll be very quick on it, and they're sort of in summary on page 2 of my brief, but my client owns a piece of property basically out on River Road, probably a couple miles west of downtown, which he was developing into a restaurant, gas station, drive-through. And when they started developing, on the side of the property there was a hill, so they had to, among other things, put up a retaining wall. We hired SP Contracting, we hired Geo Technology to draw up the plans. We hired SP Contracting to build the wall according to design. SP hired Evans Landscaping to handle the earthwork. So I had expert disclosure on June 24, 2021, and we disclosed Anthony Amicon as our expert, and we had a report, and we gave the report. No one on the other side ever said anything back to me. Nobody asked for his deposition. But instead what happened was several months later, a motion for summary judgment was filed by all the parties, and a big basis for that, or part of the basis, and there's some things they argue which aren't on appeal here, was, well, you didn't have any expert report.
Well, they said, I think it was that the report was just a report explaining how much it would cost to do the repairs, right? There was no standard of care or anything in the original report, right?
Well, the original report, and this is on page 7 of our brief, it says development of plans, and it needed new plans and specifications for replacement of the failed retaining wall. You had to obtain supplemental boring and laboratory data as needed to slope stability. We needed to increase the retaining wall's height. So it included all of that. It did include all of that. So, but when they filed their motion for summary judgment, we then got a supplemental, or we got an affidavit from the client, or from our expert, and it did, and it did expand more on his previous report. And
Well, in this particular, the affidavit, so the previous report, you'll agree, doesn't say anything about standard of care or who he, in his opinion, he thought was negligent or anything like that, right?
I think you can read his report to say that there were problems with the design and problems with the construction.
But he doesn't say whose fault it was.
He doesn't specifically say Geotech this and S&P this, but he says you can read it as saying there's problems with the design, there's problems with the construction.
Because it fell.
Because it fell.
Right. Okay, so then you produce, after they file their motion for summary judgment, you produce an affidavit.
That is correct.
Okay.
They then moved to strike, and I just looked at this morning, and their sole basis, from when I looked on the motion to strike, their sole basis was these opinions were not contained in the original report you gave us. And I'll explain that in a little bit, why I think that's important now. But the court granted the motion to strike, which, once the court granted the motion to strike, that pretty much precluded me from defending the motion for summary judgment. And again, we're not talking some little case here. Our expert report says $1.2 million in damages. So the judge said on page, and we have this verbatim on page 10, I wasn't sure exactly why the judge granted the motion to strike, because the entry just says we're incorporating what she said on the record. So they moved. The motion to strike was basically, hey, these are new opinions, you can't bring these new opinions.
So it's new and it's beyond the dedeadline.
That's what
the grounds.
that's what, when you look at their motion to strike, that's what they moved on. The judge, though, said, and I don't see this in their motion to strike, the judge then says, and this is on page 10, and we went into great detail in his affidavit on specifically what they did wrong. I mean, if you look, basically it was Geotech, and it says this in paragraph 6 of his affidavit, you designed this thing way too steep, and then in paragraph 7, then your way of dealing with it wasn't done sufficiently as far as what your, it was an inadequate for the design pile embedment lengths, they needed to be longer. But then he further says, hey, S&P, you on the drawings, on some of the piles that you put in, you didn't put them in per the drawings. They weren't deep enough, but at the same time, Geotechnical was supposed to, they were also hired to inspect this, and they didn't inspect it properly even after it was done. So that's all in paragraph 6, paragraph 7 of his affidavit. And the court says, the trial court says, well, I don't really find, she goes, in that affidavit you filed on December 3rd, I believe it was, I really don't find that meets the definition of either report or supplemental report, because she goes, it just makes conclusions. I just see lots of conclusions. So I'm reading this and I'm thinking she didn't, maybe not, but it appears to me that the reason she struck it was because she thought her affidavit contained conclusions, and it contains, very detailed analysis of what went wrong here. So I would say the court, when they said it was just conclusions, of course, all experts make conclusions, they have to, but he just doesn't say in this affidavit, which is 4 pages long and has 17 paragraphs, and he just doesn't say, oh, they're wrong, and leaves it at that. He goes through very specifically, very detailed.
So you're saying he does give the basis and reasons for
Absolutely.
his conclusions?
Absolutely.
And that part of her decision to strike was because
Yes.
she believed he didn't?
Yeah, and and he goes into great detail in his affidavit. Like I said, and we, in paragraph, we have 7 bullet points on pages 11 and 12 of our brief that summarize this. It's too steep. et cetera, which I just went through.
And what you're saying is that the grounds for the motion to strike was that it was late?
Correct,
Okay.
correct.
And so that, but that was also a reason why she struck it?
I don't know, because it's part of this is I was reading this last night, and so I said, well, it appears that was the basis that they brought it. But.
She mentions the deadline, 30 days before
Yeah,
trial.
I think that had something to do with it, but.
So how would that, I mean, if there's a court order that you're to provide expert reports by a certain deadline and you don't, how did she abuse her discretion in granting the motion to strike?
Because, number one, we did provide a report. We did provide a
Well,
report.
you provided not a report
I-
on standard of care, though.
We provided a report that addressed his opinions, number one. Number two, and the rule says this, you can supplement your opinions, the experts can supplement their opinions within 30 days of trial.
But how is that a supplement?
Because and the rule doesn't say, hey, you're only allowed to supplement this, or you're limited on supplementation on this. The rule says, and I was thinking about this last night, I mean, as it says here, but the rule does not give any limitations on supplementation. The rule says you can supplement within 30 days of trial, and that's what we did. It doesn't say, here's your limitations on supplementation.
But what does that mean, though? I mean, it doesn't mean that you can add a completely new opinion
Sure
or
it
a new
does.
subject matter that you never, does it?
Yeah, that's exactly why it talks about supplementation. I mean, part of it would be, for example, let's suppose let's suppose they deposed this guy, my expert, and he gave 4 opinions. In 45 days before trial, he said, ooh, I've got a brand new opinion on this. Now, obviously, that's not what happened in this case, but he said, I got a brand new opinion on that. That's what Rule 26 allows you to do, is you say, all right, if you got new opinions, or if you have things to supplement, you can do it, you just got to do it 30 days before trial. I mean, that's what the rule says. I mean, that's verbatim reading of the rule. And again, there's no limitation, there's really no explanation, it just says you can supplement, and that's what we did.
Well, but let me ask you, Mr. Fagel, it sounds
Sure.
like the trial court didn't consider the first report to be an expert report, so there was a supplement, at least in the trial court's mind, supplement of nothing. Do you understand?
No, I don't think the trial court ever said our first report was not an expert report. I don't think there's any dispute, at least that I'm aware of, that his first report that I produced, I don't think anybody, and I don't think they even argued that.
She does. She says, I don't think your original 2 reports that you filed are more than cost analysis construction. I really don't think that they're expert reports. I mean, she does say that.
I'm sorry, what are you reading from?
When she, in the transcript.
Okay, all right.
She said she did
And I'm
not
wrong on
believe
that.
that your first report was anything more than a cost analysis construction.
Well, first of all, that is an expert report because he goes through in great detail. Let me put it this way, I'm a lawyer, I can't go through in great detail, line by line, on what it's going to cost to redo what went wrong with the Hill, what needs to be redone with the Hill, and $1.2 million to fix the Hill. That is an expert report by an expert. The lay person can't come in and say, can't do that, and it's I've got the report in front of me. I mean, it's itemized, it's multiple pages on everything that went wrong. So since the judge said that, since the judge said, I would say, again, that's not accurate. When you say, I mean, this is the report, line by line on the cost of each thing and each specific thing that needs to be done, and I think to say that's not an expert report, I'm not sure. I'll just leave it at this. I don't agree with the judge at all when she says that's not an expert report. That's not a layman that could put that together.
Let me ask you another, on this,
Sure.
the affidavit you mentioned in supplement of the report, there's no mention of Evans in that affidavit, is there? Or if
What's
there is,
that?
there's no mention of Evans, whatever, you say, I got the
Okay,
report,
well,
and I supplement it, and
yeah,
then
okay,
there's
well, I'll get-
nothing relating
yeah.
to Evans
So-
in the affidavit.
So So on, how much time do I have left?
You're at the end of your time, but you can answer Judge Winkler's question.
rats.
And you have 4 minutes. Well,
Rats.
this won't cut into your 4 minutes, but you can
Okay.
answer Judge
Can I,
Winkler's.
let me do this then. Can I take more than my 4 minutes? 'Cause I do want to,
You
well-
can answer his question. I won't count it against your rebuttal time.
all right, well, thank you.
Yes, because he asked you a question.
As it relates to Evans, this is on page 18 and 19 of my brief. My expert did not find any fault with Evans. The problem is that one of their experts found fault with Evans. So I am, and this is geotechnical, their expert, Mr. Castro. This is on page 19 of my brief, and we say it verbatim. And for time purpose, I won't read it, but he talks about basically the work done by the earthwork contractor, which is Evans. It was done faulty and, this, et cetera, et cetera. So we were relying on, because I didn't want to be a trial and have them say, empty chair, it's Evans' fault, blame them. Well, I can rely on other experts. So, and that's what we were doing as it relates to Evans. So I'll have more to say, but I'll say it when I get back
You'll
up.
have
Thank
your
you.
4 minutes. Thank you so much. Mr. Black?
If it please the court, my name is Sean Blatt. I represent Geotechnology, Inc. I guess I want to correct one factual statement that was made here, that the wall has fallen. The wall has not fallen. It's still standing, and it's still retaining soil to this
Is it
day.
leaning?
It's leaning.
Okay.
Okay. So I just want to make sure that that's clear, and that the restaurant's still open, the gas station's still, everything there works and is operating. The trial court properly struck the affidavit of Mr. Amicon and did not abuse its discretion when doing so. This case, as the court is aware, was a refiling of the prior case with essentially the same identical allegations that started in 2019. We were litigating this case for approximately 1 year. The original two opinions that were delivered to us, or I should say, the original two reports that came when Mr. Amicon was identified as an expert, and he was the only expert identified, included simply cost estimates. This is what it's going to cost to what his opinion was to fix the problem. It was 3 times the long wall, higher wall, and they were going to regrade the entire hillside. And then there was another report that included some more fee estimates. There was no opinion as to standard of care. There was no reasons given for any of these numbers that he put in there. And the rule 26B7 mandates that any report of an expert has to include full opinions, all the opinions he intends to render, as well as reasons for those opinions, meaning the basis and the reason why he holds those opinions. So those two opinions, or those two reports, weren't valid under 26B7.
So you agree with the trial judge that
Yes.
that was not an expert report?
Right. It didn't contain anything in terms of his opinions and his reasoning at all. And let me tell you, Mr. Amicon can write such a report. He's an expert witness that I've deposed in years past. So it's not like he doesn't know how to do that.
Well, why isn't the affidavit a supplement then?
Because the affidavit, first of all, when you're talking about supplement, now that term isn't defined in the statute, but supplement itself acknowledges that what you really mean is something has happened since you issued your original report. That is, there's a change in facts, perhaps a change in conditions, or something that mandates that you have to go back and readdress something in the original thing that creates new conditions that you couldn't anticipate at the time.
Well, what about Mr. Fagel's example of a deposition where the expert then says, oh, and hey, I just thought of another reason or opinion?
I would say that that's not supplement.
That wouldn't be allowed to be supplemented?
No, because nothing has changed, nothing has altered. He's required to put all of his opinions in as best as he can to evaluate and analyze the condition. Remember, we had litigated this case for a year up to December of that year and prior, in the years prior. The court properly struck it also, and the court is entitled to look at other reasons. when it is deciding motions to strike an affidavit or an expert opinion. In this case, the court acknowledged correctly that all of the statements contained in that opinion, in that affidavit that was delivered to us about a month before the trial and after we had all filed summary judgment, the court acknowledged that it's really just conclusions. And if you read the affidavit does not set forth a standard of care for the engineering requirements. The affidavit does not identify the reasons. And in fact, the affidavit doesn't identify all of the opinions. If you read paragraph 7, which is where he begins to talk about his alleged opinions about geotechnology, he says the pile and lagging retaining wall failure is due to geotechnology's improper design/design errors that was exacerbated by defendant SP Contracting LLC, DBA SP Drilling and Contracting, improper construction and construction certification. And then he says, the next statement is for instance. So he's giving one example of alleged design errors. And he says, for instance, geotechnology's errors ultimately led to the inadequate and deficient design pile embedment lengths for the retaining wall such that the structure is incapable of properly retaining the hillside. Here's what he doesn't say. What's wrong with the embedment lengths? He says they're deficiently designed. Again, he's just giving conclusions without telling us the reasons why. And Rule 26 expressly says that it must, the report must disclose a complete statement of all opinions and the basis and reasons for them as to each matter the opinion will, or the expert will testify.
So
Now-
saying that SP Contracting did not correctly install some of the piles, not good enough?
Right, he has
for
to
a
say,
report?
right, explain why, how is it not correctly installed? How did they fail to properly install it?
But is that not enough to give notice, and then you can do a deposition or a Daubert hearing or something like that? I mean, how is this not enough to provide notice?
It provides notice that he has an opinion that there's a defect, but again, Rule 26 specifically, the staff notes state that the reason for this change, one of the main reasons was that perhaps you won't need to take a deposition. If the proper description and opinions that are rendered are enough that you can take notice of all of the information and know the basis for it. Now, it is correct that if that information had been delivered back originally and we had that information, we could have perhaps taken a deposition, and that would have been splitting hairs perhaps if we were standing here again because we moved back then. But that's not what happened. This happened after we had already delivered our expert reports, after we filed for summary judgment, and about a month later, these new opinions came up.
But that's what your main argument is, that it was late. It didn't comply with the rule.
Well, our opinion is that it's late, and the court is correct that it still doesn't comply as a Rule 26 report, because the report solely doesn't identify any design errors, doesn't set forth any standard of care for a design engineer that they're supposed to meet. And I'll point out that he also makes a note that under paragraph 8, he says, further, the unstable steep hillside slopes are the result of geotechnology's erred analysis of the hillside slope stability, combined with substandard design factors. He doesn't say anything about what any of those are. Now, let me be clear. This isn't the first retaining wall case I've had. And in fact, slope stability analysis is a term of art in this industry. And it is a computer program. And you have to do soil borings. You have to pull up the soil. You look at it. You got to input soil strengths, shear factors. You have to know where the depth of the bedrock. You have to know if there's subterranean water. And all this goes into a program. And then it puts out a nice analysis and a graph, and the engineer is able to take that and then design the proper kind of wall. And so, and in fact, I know Mr. Amicon knows how to do this because on other cases I've deposed him on, we've talked about the slope stability analysis and the multiple factors that go into this. Even if this was his report, we wouldn't have any idea what his opinion is as to how this is defectively designed. And the whole point of Rule 26 and the changes that were rendered, and based on the court's own issues of, I say I'm out of time, so I apologize.
You are. I was going to let you finish your thought.
Okay, well, but I would just simply end with, the court clearly did not abuse discretion after a year of litigation when these issues all should have been raised and addressed at the appropriate time. Thank you.
Thank you so much. Whoever's going to argue next?
I don't want to confuse it, so.
We have Mr. Spillane, and you have 5 minutes.
Thank you, Your Honor.
Let me ask you, Mr. Spillane.
Yes, Your Honor.
Had discovery closed in this matter pursuant to the scheduling order? I know the trial date was looming later in the month. I knew this hearing was on December 3rd, and I think the court had scheduled the trial for later that month. Am I correct or incorrect in that? Or?
I think your assessment's fair, but I don't want to misrepresent the facts of the court. I don't remember the discovery cutoff, Judge Winkler. But you're right, it was about 45 days or so from trial.
Okay.
And we moved for summary judgment for the reasons Mr. Blatt explained, and a motion to strike as well following that. Judge Krause, you really encapsulated it very well in some of your earlier comments. And I wrote my notes very quickly, so I don't want to mischaracterize what you said. It's on the record. You asked Mr. Fagel, here is this October 19, 2019 engineer's opinion of probable construction costs, and it had all those numbers, and it says $1.2 million. And your response was, because it fell. That's all we had, is we need $1.2 million because it fell. We have no standard of care analysis. You have 3 different disciplines as defendants in this case, and then Evans Landscaping also added the surveyor, who's not before the court today, Cardinal Engineering. So you essentially had 4 people in this case, or 4 entities in this case, a professional licensed engineer who designed the wall. And let's talk about the retaining wall. My client installed a steel cast-in pile retaining wall with 32 steel rods driven in the ground. This isn't a small retaining wall you see on the east side of Cincinnati around somebody's yard. This is a very large wall. It's a very technical wall to build. That's why they had geotechnology. That's why my client installed the steel piers. That's why Evans Landscaping came in behind that to do earthworks work to fill the soils around the wall. And then, of course, you had the staking and surveying contractor in Cardinal. There's a lot of people involved here. So Mr. Blatt hit it on the head, multiple disciplines, and you have no report. You have, I need $1.2 million because it fell. And that's all we had.
Somebody did something wrong. Is like the implication, right?
Your Honor, I won't even stipulate that. This area is in a known hillside landslide area. It's on the banks of the Ohio River. That toe of the slope may or may not be stable, even if it was never constructed or built.
I'm just saying from the report that was provided, or the cost analysis that was provided. I'm not saying that.
Okay, fair enough.
I thought that there was some indication in the cost analysis that there was something wrong with the construction that somebody is responsible for.
From another expert? in the
No,
case?
from here. I thought that's what, I'm sorry, I thought that's what Mr. Fagel was arguing, that the original cost analysis had some kind of information, that there was some kind of construction.
I understand.
Problem.
There were lots of small little lines behind numbers for like a line item price. I would disagree with that representation. It has no analysis, doesn't meet Daubert, doesn't give you theories, doesn't tell you why there might be a slope failure, doesn't account for the fact that that's a known landslide area. It doesn't address anything like my expert's report, which is like 90 pages, where he went through everything about what my client did to drive the steel piles into the wall, to the extent that he actually looked at the auger bit used to drill in the ground to make sure that it was the right auger bit to go with the steel pile. That's how detailed we got. And the importance about that is, when a trial court issues a scheduling order, my clients tend to follow it. So when I didn't get a report with analysis, standard of care, evaluations, criticisms, opinions, many lawyers, I can't speak for anybody in this room, might say, if you don't have a report, I'm not going to get a report. But I got a report, and as I argued to Judge Lubers, you told me to get a report, I got a report, and that's why we're ready to proceed if he would have had a report. But that's why we moved for summary judgment. I'm not hearing anything in Mr. Fagel's argument about how there is an abuse of discretion in Judge Luber's decision to strike the affidavit. The transcripts before the court, we had at least a 45-minute hearing before the court on all of these issues. She was prepared, she was thorough about her analysis. She struck the affidavit. It's in the brief on the grounds for that.
He's arguing that her main ground, the way he interprets what she did, is that she struck it because she didn't believe the affidavit was supplemental. And he's saying it was supplemental.
I
I
do-
mean, he's saying that's how she abused her discretion because she was wrong in saying that.
I do, well, respectfully, Your Honor, I don't believe Judge Luber's abused her discretion in that regard. I don't believe that affidavit at all was supplemental, because as Mr. Blatt argued, when he went through the litany of what happens when you go and do soil stability analysis, that should have been in the initial report. If Mr. Anacon had criticism about how the piles were driven into the ground, then he should have written eloquently why my client did not meet the standard of care as a piles contractor working in Southwest Ohio. If he had opinions about how geotechnology might have failed to adhere to the standard of care for supervising the site while my client was working on it, he should have put that in a report and issued it by the deadline. We never got a request for an extension. We never got anything other than this $1.2 million estimate because the wall fell, and then there was a January 22nd, 21 retaining wall hillside stabilization designs construction support fee, which just increased the price of the fix. That's all we had to go on. I had to file a motion summary judgment, just like my fellow defendants and third-party defendants in this case, as I didn't have anything in terms of opinions that were critical or negative or adverse to my client as we proceeded to trial.
Well, thank you. You are at your
I'll yield the
time.
rest of my time.
All right.
Thank you, Your Honors.
Thank you. And we have Mr. O'Connor. You have 3 minutes.
I will try to be less than that. I had Evans Landscaping move some dirt on this project. We've heard Mr. Fagel say that his expert didn't find any fault with what Evans did. Just like Mr. Spilly, we went out and timely submitted our own expert report who said we didn't do anything wrong. No genuine issue of material fact. Both sides agree. Nobody's pointing fingers at Evans. I agree with...
Well, wait, somebody's pointing fingers. The other experts for the appellees, or I forget which one, was pointing fingers at Evans, right? And that's what Mr. Fagel wants to use as his expert report.
That's correct, Your Honor. However, if these parties are out of the case, I don't know how Mr. Fagel is going to walk in at trial and present evidence of what their experts who are no longer in the case and no longer are testifying. So there's still no genuine issue of material fact in the trial or in the record. I want to get to the question that Your Honor posed about whether this was a supplemental report or not. I heard Mr. Fagel say in his argument that the rule doesn't limit what you could supplement in your report. Let's think about that. All that's going to do, if that's the interpretation that this court adopts, is to encourage sandbagging. It's going to encourage people to put out as minimal a report as possible by the deadline in Civil Rule 26 and the case management order, and then 30 or 45 days before trial come out with a whole new plethora of stuff where people are racing 30, 45 days before trial to depose an expert. It's not what the rules are intended. Unless the court has any questions, I'll ask you to affirm and I'll sit down.
You actually really did well there.
Thank you.
Thank you. Mr. Fagel, you have 4 minutes for rebuttal.
I was not internet surfing. I was looking up the definition of supplement.
Okay.
And supplement, this is just from reading something that completes or enhances something else. So that's what this
How did
report
it, I
did.
mean, how did it complete or enhance?
Well,
the
because
prior
it
report?
because it gave additional opinions on, and it gave further analysis and opinions on what he had already said as it relates to the two defendants that he found fault on.
But it really wasn't further analysis, was it? I mean, I'm just, can you respond to Mr. O'Connor's last argument about, I mean, if we agree with you that this is a supplement, aren't we essentially saying that you can put out just something, anything, by the deadline, and then sandbag people later on with additional more complex opinions that actually might require a deposition?
Well, you know, we as a general rule of thumb, I don't think attorneys sit around and think that, because quite frankly, in fact, I'm going to say no, because quite frankly, you don't want to go back, and I know this firsthand, you don't want to go back to your expert and go have to spend thousands and thousands of more dollars to go get supplementary reports. No attorney wants to do this, and no attorney wants to be in the position I'm in right now. So I don't agree with that. I'm going to spin this a little bit, though, and say and in all due respect to counsel, and I like him though, is, and I'm listening to these hyper-technical arguments about, oh, is this an expert report? On page 5 of their motion, it was a joint motion to strike, they refer to our initial report, and it says, in his expert reports. That's what they say on page 5 of their motion to strike, which again, they don't go to the sufficiency of his affidavit. It was all about being too late. They say, oh, we weren't on notice. Well, they went out and got their own experts, presumably, to rebut the initial report I gave them. They just didn't say, oh, you know.
Well, it's to rebut the allegations and the
Well, and it was to
complaint.
rebut what was put in the report as well. I mean, you don't go get your own expert if you think the other side doesn't have anything against you. And I was talking to some people in my office about this case yesterday. And, you know, cases should be decided on their merits, not on procedural maneuvering. And I don't think that these types, we shouldn't be encouraging people to purposely avoid discovery so they can win on procedural maneuvers. There was no request for a deposition in this case. There was no request for
Well,
anything.
I don't understand what they would have asked your expert. Your expert gives a cost analysis. He doesn't do any kind of standard of care saying somebody messed up, this is who messed up, this is how they messed up. This is why I believe that. He didn't say any of that. Why would they want to depose him and raise those issues?
Because you always want to find out their opinions. I mean, it's, to
But
me.
if it's not there, then they can win on summary judgment.
Pardon?
But if it's not there, then
Well, that's the
they can
point
win on
is,
summary judgment.
and that's what I'm saying is, these cases should be decided on the merits. They shouldn't be decided on procedural maneuvering of your report doesn't say this or your report doesn't say that, because if that's what we're getting into, then lawyers are walking into landmines of, oh, geez, I didn't put the, I mean, that's the kind of stuff that'll keep me laying awake at night. If I'm sitting around saying, okay, I got my expert report, here it is, and now I didn't have in a paragraph, or I didn't have this, or I didn't have that. I think, once again, these cases, and I have this on page 4 of my, or page 6. To strike an expert, it's an extreme sanction because it results in you losing the case. I mean, it's extreme. And the court says, and this is where it says you either have to show willful noncompliance. Well, there's no willful noncompliance here. I mean, there's none of that. Or you have to show unfair surprise, and that hasn't been shown either. So, I mean, this was a severe, I mean, this was the death penalty that was given to my client. I mean, we lose the case over this on procedural things where we gave the report. There's no depot, no nothing else. We supplement the report after I see that they're complaining about it. When we supplement the report, they say we're too late, but it is an expert versus an expert report, and the court says, oh, that's not even a report. And apparently the court says my first one's not a report. I'll say the last thing too was, on the whole too late thing, we have this in our brief, COVID, am I out of time?
You're out of time. I was going to check
COVID
with
hit,
Judge Winkler if he had any
and this
questions.
trial was going to get moved anyway. And all we had to do in this case, really, at that point was just continue it, because it was going to get continued anyway, continue the case, take his deposition, let's all have our day in court, let's decide this case on the merits. And that's all we're asking.
Any questions?
Thank
No,
you.
I don't. Thank you.
Thank you very much. Thank you all for your arguments today. We will take the case under submission and issue a timely decision. The next case will be Liggett versus Liggett.
Excuse me.
Well, I'll probably leave. You want to see the definition of supplement?
Am I saying the name correct?
Liggett,
Okay, good.
I mean, I got to make that joke. You were talking about digging
Okay, there we go. Gotta add some jokes to the First District Court of Appeals. Thank you. All right. How much, Mr. Smith, how much time would you like to reserve for rebuttal?
3 minutes is fine.
3 minutes? Okay, and whenever you are ready.
All right, may it please the court. This appeal is a relatively narrow issue, and it stems from the trial court's mishandling of a motion to dismiss. Some brief facts are that Mark and Susan Liggett were divorced. A decree of divorce was entered. They reached an agreement as to all issues. As time went on, there was a dispute about the payment of certain monies to my client, Susan Liggett. Those monies relate to spousal support, specifically Class II spousal support. Class II spousal support is frequently used to address variable income, non-recurring income, things of that nature. Ms. Liggett filed a motion for contempt alleging a failure to comply with the payment of Class II spousal support, seeking to enforce an entitlement under the court's decree of divorce or the court order.
So this is bonuses.
Yes.
This is the bottom line is that she gets a percentage of her ex-husband's bonuses, work bonuses.
Yeah, there's a formula and then some other conditions, but yes, essentially, there's a monies paid to him, and there is a certain, the decree directs the parties to do things with that money.
And it sounds like there were a bunch of filings ahead of time where she's trying to figure out if he got a bonus.
Correct.
And wasn't able to really concretely determine whether or not he received some sort of bonus.
Yeah, and Your Honor, I think this is a good point. One of the challenges that you have is you don't want to file a motion for contempt without some basis, you want to do discovery. So I filed a series of what I would call lightweight motions, efforts to obtain the information voluntarily or through a short court order that would provide me with the information. At each juncture, I was met with a protective order for subpoenas and a motion to dismiss. So I went from, I can't remember the order, I think there may have been 3, motion to compel, a motion for proof of income, and then finally a motion for contempt. I have to tell the court that I've essentially exhausted every effort to get the information that I need to put on my case.
But the bottom line motion for contempt is that your client suspects, based on the fact that her ex-husband received bonuses every year previously and now is saying that he did not receive a bonus, that he's somehow hiding bonus income as something else? Is that the allegation?
In essence, it is. There is, it's not just bonus income, it's all income that's not specific things. The bonus is very broadly defined.
Okay.
Bonus encapsulates any income that is not A, B, C, and D. So there are a number of things that could qualify as this incentive compensation, which is why in my motion I called it incentive compensation. It could have been a dividend, for instance.
Okay.
It could have been whatever you want to call it.
Something that's not salary.
Correct. And so the issue really is that I didn't have the chance to enforce it because the court dismissed the motion because there's not modifiability. So,
Why was this a 12B6? Like, does that apply to motions?
I don't really think so. I mean, I think it's, the standard is so low on a 12B6 motion to dismiss, especially when you allege that there's a valid court order and the violation of that, it's very atypical to see a 12B6 motion. But,
It applies to pleadings, right?
Yes.
That's complaints, answers, and replies. I mean, is a motion even a pleading?
Well, I think a pleading indicates a commencement or the initial response. Is it a plea? I mean,
is that typical to use a 12B6 on a contempt?
I've never had a 12B6 because it doesn't go to the merits, and a contempt is always, you have to do discovery and present a case.
Right.
So essentially in my appeal, I bring up this issue for a summary judgment because ultimately the court is going to give you the opportunity to present a case on the merits. Now, if there is no existing court order, I suppose a court could sua sponte dismiss the case, but that's not the case here. I mean, there is an allegation that stems from a court order, and we seek to prove our case. So does a 12B6 apply to a motion? No, I think it's a motion to dismiss. I think you would have to file a motion to dismiss and a different standard would be applied. But seeing as how, I mean, The question is, and this is not one I thought of, and I'm giving you my candid response, is do I believe that a new post-decree pleading, a new post-decree motion is a complaint or other pleading? In candor, I don't think it is, because it necessarily has a number of facts that relate to prior proceedings inherent in the pleading itself.
Right, and so then the court's not just confined to the motion itself, I mean, in deciding whether to dismiss the case. I mean, when you're looking at a 12b6, you're just looking at the complaint, right?
I suppose you are, yes?
Right, and so, I mean, that's one of
Four
the.
corners, yes.
It's one of the issues here is whether or not this affidavit, the court considered an affidavit or not.
Well, unfortunately, the hearing before the magistrate was not on the record.
That was like a Zoom hearing?
It was a Zoom hearing, yes.
Okay.
And it was not on the record. There was argument relating to this affidavit before the magistrate. And I opposed it vehemently.
We can't consider any of that, right?
You're right, we can't.
Okay.
But to your point is that there was, to your point, the magistrate did exactly what I think you're saying, which is I heard some argument from the parties, I set it for a hearing to get to the bottom of it.
Right.
And that was ultimately the status of that was why there was a motion to set aside, because the magistrate said, we'll have a hearing and we'll get to the bottom of this.
And so what was it sounded like the judge said, I'm not going to consider the affidavit, I'm only going to look at, I guess, the motion allegations, right?
No, it's more nuanced than that, because he says, I looked at the pleadings, okay? I reviewed the record. Now, this record was infected with this affidavit. Not only was it attached to a pleading, it was incorporated into the motion. On page 8 of Mr. Liggett's motion to set aside, it recites the entirety of the affidavit. And it says, we prove there is nothing to enforce. Therefore, your only analysis is whether there is modifiability. And the court says, you know what? There's no modifiability. I'm going to dismiss the case.
So I don't have jurisdiction to modify. That's what the
Correct.
judge
And
said.
I would agree with that, yes. But I don't have any, I have no, I was not given the opportunity to enforce it. In other words, the court relied on an argument without any real evidence, without my ability to contradict the information in the affidavit, to decide that I couldn't enforce it, and therefore my only relief was modifying it, to which I was not entitled.
Let me ask you that,
Yes.
Mr. Smith. I think we're all in agreement that you can't modify the divorce decree, but my understanding is that what I'll just in general terms call spousal support was incorporated into a separation agreement, which then in turn was incorporated into the decree of divorce, allowing you, in essence, to go back to the domestic relations court and request more spousal support. I mean, am I correct in that or incorrect?
You are and you aren't. I mean, for the purposes of our discussion, because I'm talking about Class 2 spousal support, I would stipulate that there's no modifiability. There are provisions that would permit the court to change spousal support under certain circumstances.
Okay.
Those are not present, and I'm not alleging those. But for the purposes, to get more spousal support, to get a blanket look at it, there were agreements that confined the payments.
But it sounds like at least your client believes that there's something going on here.
Yeah.
The bonus got rolled into salary or something, or a car or a boat, or some other accoutrement of employment, it sounds like.
That's exactly right. And we sought to evaluate that. And we did that by filing a motion so we could do formal discovery. We were thwarted at every turn, and the court erroneously dismissed our case based upon modifiability and not enforcement. To the extent that I do want to hammer home one small point, and then I'll bail if there's no further questions, but the idea is that if we're looking at the standard of changing a motion to dismiss to a motion for summary judgment, which I brought up in my response to the motion to set aside and as well as this appeal, if we're looking at the idea that a court has to specifically rely upon matters outside of the pleading to violate the rule, I would say that this court did something that's fairly concerning. If you look at the judge's decision, it said, I reviewed the record, there's no modifiability, dismissal. The only way you can get to that is to believe that the allegations set forth by Mr. Liggett were accurate. You have to rely on the fact that he believes he proved by virtue of a self-serving affidavit
That he did not get a bonus.
that there's nothing to enforce.
Right.
You don't need discovery because I've given you this affidavit. Let's call it quits. So I leave you with that, if there's no further questions. Thank you.
Thank you. And you actually have about 5 minutes left for rebuttal if you want to use that.
Good morning, Your Honors. So in response to the question that you asked, whether you can do a 12B6 on a motion, the motion is what restarts the case. So originally a divorce complaint is filed, and then there can be all kinds of various motions and stuff that are not, initial pleadings. And then once the decree goes on, the case is considered done. So something comes in that acts as a complaint that restarts the case, which is a motion. So that's why I believe the 12B6 applies, because that's what's bringing this to the court. You have to reserve it per the civil rules, by certified mail, all of those things that apply to a complaint.
Do you have, is this typical? Do you have other cases for contempt motions where 12B6 is used? Is that
No, I think it's unusual. It absolutely applies, but it is unusual for somebody to not actually state an actionable case. I think that's just normally unusual.
Wait, how was it not stated in the complaint?
Because
Or the motion, I'm sorry.
Because he flat out said in his motion that husband has not received bonuses, period. He has not, it says right in his complaint, husband has not received bonuses, but we think he's getting it in another form. And as Judge Winkler said, well, what if it's gotten rolled into a salary? Salary has been absolutely defined as not a bonus, and it's not modifiable.
What about a car?
What-
Judge Winkler said a car or a boat as well.
Well, the point is, in the complaint, he flat out said he's not getting a bonus. So that's, by complaint, I mean motion. So in his initial filing that started this, in the motion, he's not getting a bonus. And then he says, well, but he's getting some other kind of incentive compensation. And then he defines incentive compensation. And then, again, I'm losing track of what was in the actual motion and what was in his appellate brief. But somewhere in one of those two, he says that incentive compensation is defined in such and such dictionary as. That is completely irrelevant. What she's not entitled to incentive compensation. That's not in there anywhere. She is entitled to what we defined as bonus.
And how is that defined?
I don't have the decree with me, but it says not salary, among other things. Bonus specifically does not include salary, this, that, the other thing. There's a list of things that it doesn't include. The point of but his motion flat out said she's not getting a bonus, but we think that she is getting it some other way. So he defined himself out of a case right there. And now he went to
Bonus is in the, it's defined, it says what a bonus is not.
Right.
But it doesn't say what a bonus is.
Exactly.
Okay.
It says what it is not. But Mr. Smith flat out said he's not getting a bonus. So in the complaint, he defined himself right out of it because he says it's not a bonus, but it's something else. Well, if it's not a bonus, which is a defined term, he's the one who said it's not a bonus, then he can't argue that he should get something else because it is not modifiable. I mean, as far as the affidavit, he's saying that he should have gotten discovery because there was an affidavit. I think the Holloman case is very clear that an affidavit was irrelevant, so since there was no indication that the court relied on it, and the court did not give any notice that it was treating it as the motion for summary judgment, and the entry is extremely short. And it says right in it, in this very short little entry, when considering a Civil Rule 60B motion, the court may not rely on evidence outside of the complaint. So very, very clearly, not relying on any evidence outside of the complaint. So I think the first appellate point is clearly not correct.
So your argument is simply that because the motion says it's not a bonus.
Right.
That's it, we're done. If it had said he's getting a bonus in another form,
No, because in another form, he said it's not a bonus. If he said he got a bonus and hasn't paid it, that would have been actionable. But he
Does
didn't.
it have to be called a bonus?
He's the one, look, I am entitled to a short and plain statement of the case. It was a very, very vague motion. It didn't really say anything in the motion. It didn't say this. Normally, when you do a contempt motion, this is the clause and this is the violation. And I've never seen one that has not been clear like that. But there was an affidavit, and as I said in my brief, the closest thing he came to an accusation that my client actually violated a court order is that he was getting a bonus in another form. And Mr. Smith has changed his language a lot in the documents, and I think it was in his appellate brief. Now he's using the term incentive compensation, and he defines it by a dictionary. But, saying he got a bonus and he didn't pay it, okay, that is an actionable thing. But to say he didn't get a bonus, well, once you say you didn't get a bonus, case done.
Understand.
Okay. That's all I have, if you have nothing else.
Anything?
Thank you.
No? Thank you.
Well, forgive me for being on my phone, but I looked up my initial pleading, and I didn't bonus my way out of anything. I think a primary mistake on behalf of Mr. Liggett is forgetting two very important words in the decree. A bonus shall include any income, car allowance, HSA contribution, dividend. It could be a appreciation award.
But does your motion say he didn't get a bonus?
My motion says,
I mean, that's the argument, is that you say he didn't get a bonus, and now you're saying, well, a bonus can include anything, so the motion should have said he got a bonus of some sort.
my motion says Mark continues to receive this incentive compensation in another form as refused to pay Susan her share as required by section 12.2 of the decree.
What's the part of the decree that
12.2.
do you not say that he didn't get a bonus? In your not in the decree, in your motion. Oh, that's the decree. I'm looking, I mean, I don't have your motion in front of me.
It says, I indicate, I restate on September 19th, shortly after receiving the letter from Mark's employer, Susan requested the last pay stub. It says, I asked about whether my client reached out to Mr. Liggett to indicate to ask whether or not he got a bonus, and he just said no. And I said, Mark continues to receive this incentive compensation in another form as refused to pay Susan her share.
Okay, I got
So
you.
my point is that even if, I think he may have recharacterized it and say, oh, I don't get a line item bonus, I get a boat or a car. And so I'm covering the bases to say, because what I'm getting is one word answers say, I don't get a bonus. Well, there's a lot of different ways for me to get to Class 2 spousal support. It's broadly defined. So if I want to call it incentive compensation would fall into the category of any income. It is by virtue of the breadth of the definition in the decree inclusive of a bonus. You can call it incentive income, you can call it, bonus can be a number of different things. So to call it incentive income does not essentially define my way out of the pleading. If the court has no further questions, I have nothing for.
I don't. Thank you.
Thank you. Thank you both for your arguments this morning. We will take the case under submission and issue a timely decision.
Thank you, Your Honor.
Thank you.
I'll let you all get cleared out for the next case. So we have next, I'm pronouncing it, Brazil?
It's Brazil, Your Honor.
Brazil, okay. Versus Infrastructure and Development Engineering. I've been looking at this name the whole time thinking, how do you say that? Brazil, and it's Mr. Conti?
Conti, yes.
Yes. How much time would you like for rebuttal?
3 minutes.
3 minutes? Whenever you're ready.
Good morning, Your Honors. This morning, I have the privilege and honor of representing the Brazils. They're a husband and wife with 3 children that purchased what they thought was going to be their dream home. It actually turned into a nightmare because the home has been substantially damaged by a landslide. Seems like a landslide morning this morning.
Yeah, I know. We got a theme today.
That's right. And the landslides continue to be active, causing more and more property damage. So just to give you some context, I wanted to sort of outline the timeline of events here. So in 2015, after conducting a geotechnical investigation, IDE oversees, tests, and signs off on the placement of a substantial amount of fill soil upon which the house is going to be built. And then F&T constructs the home on top of that fill soil. F&T is the contractor that's out of business. Essentially in reliance on the certifications of IDE, F&T says, okay, the fill soil must be good, we're going to go ahead and construct the home here. So then what happens is in 2017, when the house is for sale, after it's been constructed, the Brazils actually ask a question. When they're looking at the house, they ask about the foundation. It's a hilly area, and they ask about the foundation. Is it solid? Is it sitting on proper soil? And F&T responds to that question and says, yes, it's great. It's better than 99% of the foundations in the area. Later then in 2017, after the Brazils purchase the home, they hire a separate contractor, Bizak Landscaping, who does an entirely separate project. They construct a big pool area in the back of the house with a large retaining wall. They do a lot of landscaping, those sort of things. So then when you fast forward until March of 2021, that's when the landslide begins. So the landslide begins there on the northwest side of the house, and that's a result, at least according to the engineers, and the report was in the lower court briefings, that's a result of the improper fill and the improper placement of fill. Both of which were in violation of IDE's own geotechnical report. So the Brazils file suit after the landslide a few months later, and as I said, the landslide remains active. So to date, the landslide has caused substantial property damage. The lower court, as you know, dismissed this case based on the economic loss doctrine. The Brazils are not seeking purely economic loss here. So just to give you a list of the property damage that's occurred here, the foundation has been undermined and is cracking. The basement slab is separating from the foundation walls. The cable, the gas, and the utility lines have been severed. The pool and the intakes installed by Bizak in a separate project have been damaged. The pool pump, the pool heater installed by Bizak have been damaged. The landscaping installed by Bizak has been damaged. The retaining wall, the big retaining wall that's constructed in the back of the house to hold up the pool area has been damaged. The retaining wall, a different retaining wall near the front of the house on the northwest side of the house has also been damaged. The sewer pipe running from the house to the street has ruptured, which caused water to flood the basement and damage drywall, damage carpeting, all that sort of thing. There's drywall in areas that are cracking as a result of the house settling down from the landslide. And there are door frames in some areas that have been damaged. So this is tangible damage to tangible property.
How would you define economic loss then?
So purely economic loss is when you're seeking a purely economic loss. A lot of the economic loss cases are when accountants, there's a lost profit, there's that sort of thing. Now IDE has made the argument that purely economic loss includes the remediation of the landslide itself, right? Now some cases may say, okay, that's the product itself, right? I disagree with that because I don't think IDE actually constructed the hillside. But some cases would say the remediation of the landslide itself, that's their argument.
That's from product liability.
That's from product liability, correct, is as a purely economic loss. And I think that's what confused the lower court, to be honest with you. But we're not seeking just the remediation of the landslide. There's damage to other property, right? It's not just you have to fix the hillside. It's that you have to fix all this other property damage associated with the house that has absolutely nothing to do with IDE's work, right? So IDE was there and provided services. They provided testing services, they certified the fill, and then they were gone. Or F&T constructed the house. So if you're going to follow product liability law, right, the house is really F&T's product. It's not IDE's product, right? IDE might argue the hillside is its product, and therefore putting up a retaining wall, a pier wall, which is what's needed to hold up the hillside, is a purely economic loss, the costs associated with it. That's essentially their argument. But that's not the only thing we're seeking here. And there's an exception to the economic loss rule that says, look, when there's damage to other property, that opens the door, right, to all losses, right? So if, for example, the Queen City Terminals case, which we cited in our brief, it basically says, look, in tort, right, you can't seek purely intangible economic loss, but there is a duty, a tort duty, to avoid losses to others that arise from tangible damage to persons and to property. And that's what's happened here. This is not a purely economic loss case. If it was just a landslide with no associated property damage whatsoever, right, and it was just a landslide, then we would argue about the law with respect to whether there's remediation costs are purely economic losses. And we could have that argument. But we don't even have to get there because there's so much property damage in this case, it's not a purely economic loss case. So tort law, if you read Floorcraft, right, tort law, basically the policy of tort law is to preserve the safety of persons and property. We've sued IDE in tort, right, because there was no contract. There's no privity of
You have
contract.
professional negligence and gross negligence.
And gross negligence, correct.
Right.
For professional negligence.
So it's basically like a violation of a standard of care type of argument.
Correct,
Okay.
correct. They violated their standard of care.
It's not based on any of the contractual terms that were between the company that went out of business and
Correct.
IDE.
Correct,
Okay.
correct. And if you look at Ohio law, there's absolutely no other court in Ohio that has ever said a claim for tangible damage to tangible property is barred by the economic loss rule. This is the first time I've ever seen this, where a court, in this case, the lower court said, no, you're barred. And again, I think the lower court got confused.
Well, that's what I was having a hard time understanding, because any kind of property damage as a result of a tort necessarily would be the money to fix the damage, right? I mean, so.
Correct. And judges get confused by the economic loss rule, frankly. I mean, they do. It's a complicated rule, but it's not, the key here is looking at damage to other property, right? And there's a voluminous list of damage to other property. And it's only getting worse because the landslide is active. If this house suffers more damage and the landslide continues to move as it is doing right now, it's going to be a catastrophic loss. The whole side of the house is going to fall down the hill.
So if your client had a business that they were running out of the home, and then they couldn't run the business out of the home because of the damage, then that would be economic
That would
loss.
be economic loss.
Okay.
But this is damage to property. This is actual damage to property. And therefore, the economic loss rule is inapplicable. Now, IDE also argues essentially an integrated product rule, right, which is a product liability thing, which says, look, if you've got a multi-component product and your component to that product causes damage to that product itself, right, then any damage associated to the bigger product is barred under the economic loss rule. But this isn't a product liability case, and two, IDE doesn't have a product here.
Has this ever been applied outside the product liability?
I've not seen it applied outside the product liability realm. And again, IDE didn't construct the house, and IDE was not involved at all in the BZAC project, which is the results of that project have suffered substantial property damage. So this is not an integrated product case. Even if you were going to apply it, right, to a construction defect case, which is essentially what this is, a landslide case, it wouldn't apply here, right, because it's not some integrated product. IDE was not constructing the house. IDE was not involved at all in the BZAC project. The last thing to talk about in the economic loss rule, and I think this is what confused the lower court, was the rule in Haddonview, right? So when there are purely economic losses, there is an exception, right, for professional services where if there's some sort of negligent false representation that's relied upon, then it's an exception and you can recover purely economic losses. And it seems, if you read the lower court's opinion, that's what they were focused on, was Haddonview. And they never realized or never figured out that this was not an economic loss case. But even if you assume this is a Haddonview case where all we're seeking is purely economic losses, I still think we've met that burden in Haddonview because of the email exchange that occurred when the Brazils were buying the house. So IDE, right, made certifications regarding the fill that was put into the property, right? So they made that to F&T. F&T then made that representation to the potential buyers, right? And the potential buyers are the exact class of people you would expect to rely upon that. And if you look, that Haddonview rule is based on Restatement of Torts Section 552. And if you look in our briefing at illustration 9, that almost exactly parallels this case, except that was a purely economic loss case, where there was an engineer that negligently reported soil conditions causing purely economic loss, right? And because that report of those soil conditions were sent on to a class of persons upon which you could would foreseeably rely upon those representations, the court says you can recover, that illustration, the restatement indicates you can recover purely economic losses in that situation. And the lower court didn't agree with that, and that's where most of their analysis was. But again, we don't even have to get there. We really don't, because there's such massive property damage here. So
You're almost at your time.
yeah. So with that, I'll close and leave it to the other side and leave 3 minutes for rebuttal.
You have 3 minutes, yes.
Thank you.
Thank you.
May it please the court. I first want to bring to the court's attention, as this court is aware, we are seeking the court to affirm summary judgment on two different bases. The first basis is the economic loss doctrine. The second basis is the statute of limitations. You have heard nothing today about the statute of limitations issue, so I want to discuss that first.
The court didn't even go there, right?
The court didn't go there, but as this court is very well aware, the court can affirm summary judgment on alternative grounds under Court of Appeals precedents. And so there has not been any ruling on that, but I do want to discuss the statute of limitations because I do believe it's very clear and dispositive of this case. ORC 2305.09D is the statute of limitations for professional negligence claims against engineers. There's no dispute as to that. As to the 4-year statute of limitations against engineers, Ohio courts have consistently held that the 4-year statute of limitations begins to run when the negligent professional act is committed and refuse to extend the statute of limitations under a discovery rule. It is undisputed that plaintiffs in this case did not file their action within 4 years of the completion of my client's services. Accordingly, there's no dispute that they are time barred.
How does the statute of repose come into play with that then?
Well,
Because they're talking about accrual being when they discover the issue, right?
Okay.
Not when it actually happened.
Okay. Well, first of all, I think the Supreme Court has already addressed that issue in the Wright 1 case versus Jacobs. And basically what the Supreme Court has said in that decision is that the General Assembly has not adopted a discovery rule applicable to general negligence claims under RC 2305.09. This court will not interpret RC 2305.09 to include a discovery rule for professional negligence claims against accountants arising under RC 2305.09, absent legislative action on this matter. And that decision was issued in 1989. Since 1989, there has been no legislative action altering 2305.09D to add a discovery rule to that statute. And so when there's this discussion about the statute of repose, I really honestly don't know how the statute of repose has any application to how we interpret the statute of limitation under 2305.09D. Because as the Supreme Court has pointed out, and as is clearly shown in 2305.09D, there is a discovery rule in 2305.09D. The legislator specifically put a discovery rule in there for fraud actions and other actions, but they specifically declined to issue any type of discovery rule for the professional negligence claims under 2305.09D. So, I think since 1989, the legislature has clearly spoken on this issue. Supreme Court said there's no discovery rule. We've interpreted your statute, Mr. Legislature or Mrs. Legislature, and you have not included that language in there. So there is no discovery rule applicable to professional negligence claims. Since 1989, that has not changed. And as to the statute of repose, I'm unclear as to how you would apply a statute of repose to interpret 2305.09D when the Supreme Court and the legislature had already clearly interpreted their intent on that issue. Also on that topic, the Northern District of Ohio in the Lifetime Fitness versus Chagrin Valley engineering case has already addressed this very issue. And they stated in this case, under current Ohio law, the statute of limitations for a professional negligence claim begins to run at the time the negligent act is completed. In Flagstar, the Ohio Supreme Court examined whether the discovery and delayed damages rule applied in the professional negligence setting involving an appraiser. After analyzing the case law supporting both theories, the court reaffirms its previous ruling that an action for professional negligence accrues when the act is committed. The court also expressly noted that it had already rejected the delayed damage rule in a prior case. And this Lifetime Fitness case, although it is from the Northern District of Ohio, it does apply to an engineer, and it interprets Ohio case law since that 1989 decision from Investors Right 1 versus Jacobs.
Why shouldn't this court, though, if we don't agree with you on your other argument, now you're arguing statute of limitations, you want us to determine the statute of limitations, but the trial court didn't even go there. Why shouldn't we give the trial court the opportunity?
Well, first of all, I think matters are before the appellate court to affirm decisions based upon the law, based upon what is appropriate. This argument of the statute of limitations is clearly in front of the court, clearly something the court can decide on. And frankly, I think it's the duty of this court to decide these types of issues that are clearly presented to it and preserved for the court's attention. And so that's why I believe this court should issue that decision, because the law says you should. Okay. Also on this topic, the plaintiff has argued that, well, a discovery rule has been adopted for medical malpractice cases. A discovery rule has been adopted for attorney malpractice cases. So a discovery rule should also be adopted for engineering malpractice cases. Well, in making that argument, they ignore the fact that the cases interpreting the discovery rule for medical malpractice and legal malpractice, that falls under a completely different section. It falls under a different statute. So that involves courts interpreting a completely different statute. And more importantly, the Supreme Court has also already talked about this very issue that was raised about, well, there is a medical malpractice discovery rule. And again, in Investors' Right 1 versus Jacobs, the Supreme Court stated, the discovery rules adopted by this court and by the General Assembly for bodily injury claims brought under RC 2305.10 and the discovery rules determined in Oliver Super and Skidmore Super for medical and attorney malpractice claims arising under RC 2305.11A are not available to negligence claims brought under RC 2305.09D. So the Supreme Court has already clearly spoken on this issue. It's a settled area of law since 1989. Again, plaintiff's counsel, in a last-ditch effort to say that, well, the statute of limitations wasn't blown, refers to the case of Harris versus Liston, which is a case that was listed sometime in 2004, 2005, and argues that in that case, the Supreme Court determined a discovery rule applied to real property damage claims. However, that decision has no application to professional negligence claims. To interpret Harris versus Liston to mean that, oh, that discovery rule also applies to professional negligence cases would mean that Harris versus Liston overruled Investors' Right 1 versus Jacobs, which it clearly did not. There's no language whatsoever saying that they overruled that decision. So Harris versus Liston does not apply to professional negligence claims. It only applies to real property claims where professional negligence isn't alleged. And there has been a case, and in all fairness to plaintiff's counsel, this case was not cited in my brief. It's a 12th District Court of Appeals decision, James versus Partin, P-A-R-T-I-N, in which the court in the Court of Appeals clearly addressed the Harris versus Liston decision in the context of the Investors' Right 1 versus Jacobs decision and held, based on the case law, the use of the discovery rule or a delayed damage theory is not applicable to claims of professional negligence in a property damage case. So again, Ohio case law is very clear. The 4-year statute of limitations applies to this case, and the plaintiffs are time barred from bringing this claim. Going backwards to the economic loss doctrine, we're also entitled to, we also request the court affirm summary judgment on the basis of the economic loss doctrine.
So what is your definition of economic loss?
Yeah, my definition of economic loss, and to go back to this, I realize I'm using a integrated product theory into my interpretation of property loss.
And has that been used anywhere else? Do you have other cases that have done that?
I have made those arguments before in other cases. Frankly, the closest case that we have come across where that has been discussed was the case that I referenced in our pleadings, the education of Greenview local schools versus staff co-construction. But the reason why I believe that's a viable theory is because all of economic loss gets its roots from products liability. So you cannot discuss the law of the economic loss doctrine without realizing that it comes from the law of products liability. And so when I borrow from the integrated loss doctrine or product from product liability, it's because that's what we're talking about. We're talking about economic loss, and this is how the economic loss doctrine should be interpreted.
So that's what you're resting on, is that integrated theory.
Yes.
It's not any other argument. I mean, we have property damage here. You agree with that?
Yes,
right?
yes.
And it's not the argument that that you need money to repair the property, therefore that's economic loss.
Yes.
You're not making that argument.
No,
Okay.
no, because if you look at the case of HDM Pfluger Service, which I cited to, that's a case where there was a helicopter that crashed and suffered severe damage. the owner of the helicopter sued the manufacturer of the supports for the helicopter. And under that case, the court says, no, you cannot sue the individual manufacturer of the components of the helicopter because your claim is a matter of contract against the manufacturer of the helicopter as a whole. Okay? So they said.
Apply that to this case.
So applying it to this case, my client's services applied and were integrated into the construction of this home. We provided services, geotechnical engineering services for the slopes, and we also provided geotechnical engineering services for the foundations of this home. Plaintiff, in this case, is claiming that they suffered, and so our services were integrated into this entire property. Okay, so the property is the integrated product. All right, they purchased this property from the builder of the home, which was F&T Construction. They have a contract with the builder of the home for this property and this building. If they have a claim, it's a contract claim against the builder of the home.
And then the builder would go against your client.
And then the builder could go back against my client or any of the other subcontractors. And that's why it's important to maintain these contractual lines here, because we don't know the promises that he made to the owners when they bought it. He may have disclosed to them, hey, listen, here's the property. There's some slope issues out here. We're not warranting anything about the condition of the home. So that would be the ideal circumstance where a homeowner says, you know what, I'm going to buy it anyways, and if something goes wrong, I'm going to leapfrog my contract and I'm going to sue and tort the engineer. And that's why it's important to apply this integrated product doctrine to the facts of this case, because otherwise these contracts would be meaningless.
But you have not found nor cited a case, probably not in Ohio, but anywhere that has done this?
Well, I can't say, no.
Like
There's cases in other jurisdictions, but.
That have done this outside the product liability?
Yes, but I have not cited to those in my appellate brief. Matter of fact, I can think of one, and it's unfair to even raise that, for me to raise that to you, because I didn't cite to those cases in the brief. But if in your research of the decision, you certainly can cite to other jurisdictions. One jurisdiction I'm familiar of is Colorado. But at the end of the day, when you apply the integrated products theory to this case, there is not separate property damage. One thing I do want to jump into quickly.
You actually are at your time.
Okay.
So.
All right.
Judge Winkler, you have.
I don't, thank you.
Thank
you so much for your argument. 3 minutes.
Okay, try to be quick. I feel like we're arguing two separate cases here.
Well, so do I, because I mean, that was not your initial argument, but
Correct.
I
Well,
would love to hear your response.
Yeah, so the basis of the trial court's decision was the economic loss rule. Briefly on the economic loss rule, again, there's no Ohio law that says the integrated product doctrine applies to real property damage. It doesn't exist. And here you've also have the BZAC property, which they had nothing to do with, that's been damaged. So how is that integrated into their work? It's not. Getting to the statute of limitations, I don't know how you read the statute of repose, which says you can bring a claim for design, right, and engineering services up to 10 years and say it's cut off from the negligent act. If you rule that way, right, and say, look, you only get 4 years from the negligent act. You know how many homeowners and owners out there in years 5 to 10, which the statute of repose says they can bring a claim, will be completely barred from bringing a claim? I mean, that can't be the rule. And we cited Harris v. Liston because this is a real property damage case. If you look at the cases that they're relying on REIT 1, that's an accountant case. Right? That's not a real property damage case. This is a real property damage case. The statute of repose applies, If you just read the language of the statute of repose, it says it incorporates design services into damage to property, right? And it's applicable. So if the court is going to say you can suffer a landslide and file within months and be barred by the statute when you never knew it's a latent defect underneath the ground and you never knew there was an issue, then you're going to have all sorts of homeowners, other owners of property who are going to run into issues with this severe rule.
Mr. Conti, let me just ask, I think earlier in your argument or somewhere in your brief, you had indicated that your client specifically asked a question about the slope or
Correct.
whether it was stable. Were they provided the Applebee's report prior to purchasing the home, or just given assurances that everything had been taken care of?
It was an email exchange, so they didn't get the report from Appley until after they purchased the home and the landslide had occurred.
Okay, and you're right. And on the email exchange, were they given assurances that the property was stable?
Yes.
By whom?
Well, it was communicated by F&T, the contractor, to the realtor, to my clients, in reliance on that. One case I just want to address quickly, I know it says wrap up. They cite Chagrin Valley, this Northern District of Ohio case. Look, that case has a couple problems. One, it's a purely economic loss case. It's not a real property case. So it's completely distinguishable from this case. The other thing is, frankly, I think it's a wrongly decided case because it's contrary to the statute of repose. But if you're going to say we have to follow the Northern District of Ohio case, that was a case where there was essentially only economic loss to essentially the pad or whatever that they were putting in there. And here we've got all sorts of property damage. And Harris v. Liston is very clear. When you got property damage, it's the discovery rule. You get 4 years from discovery. We sued within a few months of discovery. So I don't think it applies. Thank you.
Thank you. Thank you both for your arguments this morning. We will take the case under submission and issue a timely decision.
Thank you. Appreciate it.
Have a great rest of your day.
You too.